One of the frequent questions we get at U.S. Law Shield of Pennsylvania has to do with, is there any sort of duty to lock up, store, and put away unloaded my firearms in my own house? And the general answer to that is no, there's no trigger law requirements, trigger guard law requirements in Pennsylvania or anything like that. What there is civil and criminal liability that attaches to things that have to do with is it foreseeable that the way that you keep or load or have your firearms is going to hurt another person? For example, when it comes to children, it's very simple. You have an absolute duty in Pennsylvania to make sure that children, meaning people under the age of 18, aren't going to get firearms, whether they're long guns or they're handguns or any sort of NFA items, and hurt themselves or other people. It has to be foreseeable. For example, having a 16-year-old go through 3 levels of security, maybe a punch door into a safe and through a trigger guard, that's not foreseeable. But leaving a loaded firearm on a counter during a slumber party that's loaded with a bunch of kids, yeah, that's going to be generally going to be problematic for the homeowner in that type of situation. Number 2 has to do with people that are special needs. These are people that maybe have a mental issue or have some sort of status such as that, who are over the age of 18. Those people will be treated similarly under Pennsylvania law. Again, foreseeability is going to be the key part of it. And then finally, it has to do with the aspect of an adult child who lives in your house, or an adult really, who still lives in your house who's over the age of 18. You have no general duty, absent the fact that there's some sort of mental issue that goes along with that, to protect them. They're treated as adults, and any sort of wrongdoing that they do as a consequence to using your firearm without your permission, it's going to fall on them, not on you. Again, that's for people who are over the age of 18 that live in the house. The key question here is foreseeability. Is it reasonably foreseeable that there's going to be some sort of harm that happens? And the requirement's going to be able to be pinned to a particular notion in law, and that has to do with negligence. Negligence is conduct that falls below an intentional standard, a knowing standard, and it has to do with the protection of others against a reasonable risk of harm. So negligence has to be shown in a civil case. In a criminal case, the big one's going to be what's called recklessly endangering another person, which is, did you put the person knowingly or intentionally in foreseeable harm of death or serious bodily injury? That's going to be the main one.